Kia ora koutou katoa, e hui nei I raro I te maru o tēnei whare, ki te whakawhiti kōrero mō tēnei kaupapa tino hōhunu te tiriti o Waitangi. He tino honore tēnei kia hau ki te tū nei I Wanganui I a koutou, ngā rangatira o te whakaaro me ki. Ngā mihi nui kia koutou katoa. Kia ora everybody. My name's Natalie Coates. I'm currently a practitioner at Kāhui Legal. I was an academic for a couple of years, but recently, well, a couple of years ago, made the transition to Kāhui Legal. It's an absolute privilege and an honour to be speaking among such esteemed company. When Carwyn originally asked me to attend, I looked at all the names and everyone was doctor, associate professor, professor. So I was quite humbled to be included amongst that list. I decided I would come to speak today after a little bit of hesitation because I thought I could make a contribution from a current practitioner's perspective. And I note that there's no title against my name. Sorry about that, Cowan. But I've called my talk The Rambling Musings of a Practitioner. So being aware that one of the purposes of this symposium is to really develop a program for research, my main goal is to simply make some comments on some areas that I find interesting with a view to highlighting where I think more work and thinking is required. In particular, I tend to make some comments on treaty settlements, as this is one manifestation of how the treaty is being interpreted by agreement, and also wanting to talk about some of the major challenges I see for Māori going forward once historical grievances are settled, and then sort of concluding with some of my thoughts, I guess building on Jacinta's comments on litigation and some areas where I see that there's potential there as well. So, treaty settlements. Treaty o Waitangi settlements are one way of both treaty partners, Māori and the Crown, working out and agreeing how the treaty applies. So it's interpretation by agreement. Largely as a result of almost 20 years of Crown and Māori engagement on settlements, the treaty is becoming more infused in the machinery of government and legislation, one of the points that Jacinta made. In my opinion, the treaty partners are now engaged more on the question of how, rather than whether to apply the treaty and its principles. As an observation, though, working out how the treaty should be applied is generally happening behind closed doors in negotiations and, in some instances, arbitration. So it's not an open process necessarily for everybody to engage in. We have seen a shift over time in the nature of treaty settlements. The original Treaty of Waitangi settlements were primarily financial compensation. Waikato Tainui, the first settlement in 1995, over 20 years ago now, for example, received $170 million and the opportunity to buy some properties. However, more recently, as we know, there have been some progress and platforms made in settlements that have created more of the ongoing iwi-Crown relationships. In particular, public-private partnerships have become more common. This is reflected in co-governance and co-management structures, such as the Waikato Tainui Raupatu Claims Waikato River Settlement Act 2010, the long name, and the Ngāti Tūwharetua Raukawa and Te Aroa River Iwi Waikato River Act 2010. So collectively, the Waikato River settlements. The purpose of those settlements being to restore and protect the health and well-being of the Waikato River for future generations. The settlement has multiple co-management bodies and consensus-making decision is a theme. So, for example, it establishes the Waikato River Authority, a statutory co-governance entity comprised of equal Crown and iwi representatives. This regime shared with Māori the exercise of public power as never before. There is also the recent move for legal identity in the Wanganui River Settlement and the Ngai Tūhoi Settlement, also mentioned by Jacinta. Legislation has not yet been passed in relation to the Wanganui River. However, the river, o te awa tūpua, will gain legal identity similar to that of a person or a company. Two people, one appointee from the Crown and one from Wanganui Iwi, will be appointed as pautipua, guardians, to act on behalf of the river and to protect its status, health and well-being. Similarly, as a result of the Ngai Tūhoi settlement, the Te Urewera National Park is held under the Te Urewera Act 2015, and like the Wanganui River, the area is made a separate legal entity with the rights, powers, duties and liabilities of a legal person. However, these are to be performed in the name of Te Urewera and by the Te Urewera Board. I think one of the interesting things about that settlement is the membership composition. So the first 3 years there's going to be equal representatives from the Crown and Māori, 4 and 4, or Crown and Tūhoi, sorry. But then after 3 years that changes so that there's 6 Tūhoi representatives and 3 Crown representatives. So Māori in that particular settlement will hold the veto right or the balance of power, which is again an unprecedented legal development. So these are some of the more recent examples where authority, power and decision-making are shared, and I think it represents a subtle shift in the Crown Māori constitutional relationships and is one of the more exciting areas in ways that the treaty relationship is being navigated by agreement. Although this shift is relatively subtle and incremental, it does set a precedent, and what I predict will likely happen is that some of the iwi that settled prior to some of these more creative settlements will likely, as they gain more capacity over time, seek to assume these more co-management and co-governance type frameworks. What will be interesting will be the extent to which the Crown and local government will be prepared to enter into these types of agreements without there being the impetus of settling historical claims. One example to note that is by no means reflective of the experience of all iwi is Ngaitahu down in the South Island. Although it's easier for them because they're the only iwi down there, so it's easier to deal with, well, not the only iwi down here, sorry. one of the few iwi down there. Controversial. So it's easier for the Crown just to turn to one primary body in that area. They have utilised their economic power and strategy to become a voice at most of the tables down there. So, for example, they have multiple relationship agreements with bodies like Environment Canterbury. They're also one of the 5 strategic partners and on the steering group for SERA, being the Canterbury Earthquake Recovery Authority. Now, this type of subtle shift in authority that is arising largely as a result of treaty settlements, I think, is a form of silent constitutional change that is often not overtly labelled as such. Now, the settlement of historic treaty grievances will soon be at an end. As we all know, in 2008, the National-led government committed to the aspirational goal of concluding the Treaty of Waitangi settlement negotiations by 2014. That goal obviously hasn't been met, but it's fair to note that there has been immense progress in winding those up. In the 2015 Roundup report, the Crown map indicated that there were only 2 areas of New Zealand that are not in active engagement with the Crown. So one being one of the Ngāti Toa groups and Mokai Pātea. Everyone else had either settled or was in active engagement with the Crown of doing so. There are some big settlements obviously to go. Ngāpuhi up north, watch that space as to how long that'll take. And there's other ones such as Te Runanga o Ngāti Whātua, Ngāti Whakaue, Whakatohia, the Moriori, and there's a number of others, but they are well on their way. In accordance with the government's target, historical treaty grievances will be settled within the next 3 to 6 years. The necessary corollary is that the Māori and Crown relationships are transitioning from focusing on historical grievances to navigating the ways in which future Māori and Crown relationships will be reflected in the future. Given this, I thought it would be useful to identify a couple of the challenges and opportunities for Māori in this post-historic settlement phase. I note that there are many, but I thought I'd just mention 4 of the ones that I think are important to keep an eye out on or to engage in active research on. One of them that Jacinta's actively involved in is the control or rights over natural resources. So we've had co-management and legal personality, but a major issue will obviously be the way that the government deals with water, geothermal and aquifers. It's an issue that's being discussed already, and again, it's largely being discussed behind closed doors at present. But what happens with this will set a major precedent for the way that Treaty of Waitangi issues are dealt with going forward. And I know Jacinta's done a lot of work on this, but I think that there's scope and potential for more work to be done around the options, what does the treaty require in this area and what should be done here prior to the government deciding what should happen. Another important area that I think is important for Māori is institution and capacity building. This needs to occur at a number of levels. This is a lot of the work that, well, we often come in as a result of this not being good. This needs to occur in Māori institutions. Capacity and competency building is imperative at all levels, including iwi, hapu, trust, etc. We need people that understand the complex regulatory environment that Māori organisations have to operate in, influence, tikanga, strategy, finance, negotiations, politics, etc. Māori organisations generally have to navigate multiple bottom lines in whatever they do, and you need the right people with the right skills in the right positions to be as effective as possible for communities, and this is one of our biggest challenges that we need to implement or start implementing smart training and succession plans. In conjunction with that, Crown institutions also need to be built up in their capacity in that regard to be sufficiently culturally competent to deal with Māori organisations as well, such as DOC, for example, in relation to the Urewera transition that will occur. The third issue that I just wanted to flag was collectivization. So this is about Māori working efficiently and effectively on multiple different scales, collectivising when you need to be productive, but also being able to divide up on different issues also when appropriate. Similar to how our people used to operate when we were primarily based in hapu groups but came together as iwi when you faced a common enemy. Māori need to and are finding modern and sophisticated ways of doing that at a micro and macro level. At a macro level, I think it would be interesting, I think there needs to be work, cross-collaborative work with different countries and with Indigenous people occurring. You get hints of that power with things like Idle No More and people coming on board to support that. But I think there's massive potential there, particularly with technology, to exploit the power that we have and the numbers that we have and the commonalities that we have across groups. Domestically, Māori are already utilising collectives in businesses, such as one thing that we do a bit of is using limited things such as limited partnership structures in agriculture. So that's when we bring together multiple trusts with land to engage in joint farming ventures in a way that safeguards their lands but allows them to engage in that particular way. There are small honey partnerships starting, and collective fishing ventures have been in place for many years. Groups working together on common enterprises is the way of the future and something that I think will come naturally to Māori. On a micro level, I think there's a lot of potential for work to be facilitated there as well. So on simple things such as even housing in Auckland, buying into small housing and collectivising in those unique ways, I think there's a lot of potential there. And the law needs to be modified and utilised to make this easier. 4, this is another, I think, big issue that we're going to have to face up to in a post-settlement, treaty settlement era. I think that there'll be a shift going forward and there should be more work done around what's required of the Crown in respect of inequality and in respect of social issues like the disproportionate number of Māori in jail, living in poverty, committing suicide, health, etc., etc. The Waitangi Tribunal has granted an urgent hearing of a claim alleging the Crown has failed to reduce the number of Māori in prison and high offending rates. This case will call for a type of argument that I think will likely become more important and prevalent moving into the next phase of treaty jurisprudence. And it will require a more advanced interpretation of the Treaty of Waitangi and an increased focus on what Article 3 might mean and guarantee for Māori. So I wanted to just, I'm almost there, sort of shift to the courts and I tautoko au I tō wero ki te kōti, Jacinta. I support her wero or challenge to the courts and that they need to do more work there. But I do think that there's scope for practitioners and academics to work closely together, and I think there's not enough of that occurring to help One discussion that's not really happening in New Zealand is active discussions on strategic litigation. This is a massive thing that happens. I was exposed to this a little bit when I was studying in the US, because it's a thing that they do a lot of there. And although the New Zealand context is obviously quite different to the US, we're not able to strike down laws as such. I do think that there's a lot of potential for thinking to go into this area and a lot of relationships to occur in that regard. There's significant potential in New Zealand. There's been the Takamori case that Jacinta mentioned that opened the door to make some arguments around the place of tikanga in the common law. I think that can be expanded and pushed in a number of different ways, and we should start having conversations about that. Paki case, it's another case where I think you can bring some really great arguments or pair up good factual scenarios with good arguments so that the most gains can be made in courts, as opposed to coming at it from such an ad hoc way. So I'll just leave it at that. Those are my random musings for now. It's an honour to be here amongst you all, and I look forward to some robust, vigorous debate. Kia ora koutou.